All right. So are you in love with her?
We're supposed to be getting married.
Well, not on my watch. That marriage is off. She was pregnant and she was going to be induced that day, and you decided to put your hands on her. I don't understand. I'm not going to follow that.
Even though that's her request?
No, I mean, no, even though it's a request according. And how many other children do you have?
I got 7 altogether.
All right. And what are their ages?
I'm not sure, ma'am. I don't got custody of them.
The East,
Yes, sir.
how's jail?
To be honest, it's not nice.
Great, happy, because I hope it's one of the most miserable, rotten experiences that you ever had. You know, the problem is that with all the anger that you have, if a child sees it, what are they gonna do? Right.
And
They're gonna be just like you.
23 CR 3546, State of Texas versus Larry Casillas. Can I have parties announced for the record for the state?
Thanks to the state of Texas.
Defense?
Elizabeth Russell for Larry Casillas.
Are you Larry Casillas? Counsel, have you received all the discovery? Did you review it with your attorney?
I have reviewed.
I'm sorry, with your client.
Yes, Judge.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Did you understand you're charged with assault of a pregnant person? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, we can go off the record. I'm looking at this plea bargain agreement. And there's to be no harmful or injurious contact with Stephanie Ortiz.
That's her, by her request, Judge.
I'm
We
not
filed an
following, I'm not going to follow that.
Even though that's her request?
No, I mean, no, even though it's a request, according to what I'm about to receive, he is a person who is hitting on, not in a loving manner, a pregnant person. I mean, was she pregnant at the time?
Yes, Your Honor.
So if, you know,
She's
I-
requesting, and I'm sorry, Judge, may I speak?
sure.
She's requesting it for her convenience. They've been doing custody exchanges for the last almost a year through a third-party person, and it's her request. She reached out to me, filled out an affidavit of non-prosecution and requested that. So
I'm not following that. So if you all want to withdraw your plea now, you can, but I am not doing a no harmful or injurious contact for somebody who's accused, and I haven't read the, the steps yet, who's accused of hitting a pregnant person.
that's fine, Judge. They're no longer in a relationship. The only relationship is for the benefit of their children. He has no interest in communicating with her beyond that.
All right, so I'm not going to follow that. So y'all have a choice. Either you can go to jury trial or either you all can change that part of your plea bargain agreement.
We're proceeding with the no contact, Judge.
All right, if you all want to change that. Anything you wish to say on behalf of your client?
Judge, we would just request that you follow the agreement between the state and defense. Mr. Casillas is wanting to move forward in a direction that's appropriate for his children. He understands what went wrong and he wants to take full responsibility for that. And he has had no issues since the arrest on this date, and they have been successfully co-parenting since that time. There was a CPS case, Judge, that was closed out for no finding.
All right, how old are you?
21, Your Honor.
How many children do you have?
2, Your Honor.
What are their ages?
1 year and 6 months.
1 year and what?
1 year and 6 months.
Are you employed?
Yes, Your Honor.
What do you do?
I work at Amazon at facility warehouse.
All right, so why do you keep hitting on Stephanie Ortiz? At one point, I'm assuming you loved her because you have children with her.
Yes, Your Honor.
So why do you keep hitting on her?
It was just me not being in the right state of mind, me letting my feelings get to myself and not just thinking right and thinking straight.
That makes no sense to me.
Your Honor, it was just my fault. I let my feelings get to myself, let her get in my head and
Let what?
let her get in my head, and I just reacted in a wrongful way.
No, but I mean, you're up here hitting someone. Honestly, I don't even know why I should follow this plea. But your attorney is telling me that she's filed a affidavit of non-prosecution. But according to this, she was pregnant and she was going to be induced that day, and you decided to put your hands on her. I don't understand. How is she getting in your head that you would be hitting a pregnant woman who's about to deliver your child?
No, Your Honor, what that day was in the day we were supposed to get induced. But I believe the hitting was before that. So it was just the marks that had came about.
But you still hit her while she was pregnant
Yes.
and she was close to her due date.
Yes.
Not that it's appropriate to hit anyone anyway,
No, it's not, Your Honor.
but obviously she was pregnant. And what she's saying in this documentation, I want you to tell you the reason why I'm saying no contact,
Yes, Your Honor.
because what she's saying in this police report is this is not the first time that you've been abusive to her. And the police took photos and she had bruising and swelling to the eye along with busted vessels in her eye. That's what you did. So the two children you have, is this a boy and a girl or two boys or two girls?
Girl and
All right. So what's your daughter's name? Sarabella.
she's a year and 7 months.
All right. So she's a year and 7 months. I guarantee you, she knows that you've been abusive to her mom. Do you love your daughter
I love her with all my heart.
with all your heart? Would you do anything for her?
I would, Your Honor.
I used to do CPS cases and parents would tell me I will walk through fire for my children.
Yes, Your Honor.
They would say that because they knew nobody had a fire for them to walk through.
Mhm.
But I believe you when you say you love your daughter.
Yes, Your Honor.
So how would you feel if your daughter became of age and she ends up with somebody like you who hits on her? Would you be okay with that?
I'll be very upset, Your Honor.
And so your daughter is learning what it means to show love is to hit on people, and might makes right.
Your Honor, that's
You're going to have to change your ways.
yes,
You
Your
are
Honor.
not to have any contact with Stephanie Ortiz. And anybody else you get into a relationship yet, don't let them meet your publicist. Let them meet you and tell them, hey, want to let you know, I had this abusive acts in my background,
Yes, Your Honor.
because then they can make an informed decision about whether or not they want to date you. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with Stephanie Ortiz. There's to be the BIPP course, parenting classes, that can be with rainbows. There's to be 200 hours of community service restitution. That will be waived once he completes parenting classes, regular reporting by Zoom or in person, regular UAs. If you're drug tested today, what are the results going to be?
Positive, Your Honor.
And what are you going to be positive for?
I mean, no, negative, Your Honor.
Negative? Okay. So you haven't used anything.
No, I-
I think Amazon drug tests, do
Yes,
they
yes,
not?
yes, I'm done, Judge. Yes, ma'am.
All right, there's to be regular UAs. I'm going to want field visits one time every 3 months, proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. Probation, is there anything else he needs?
You already did mention the regular.
Yes. All right, is there anything else you need from the court in order to be successful?
No, Your Honor. Thank you. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 PF 00972. There's an affirmative finding of family violence and no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition or be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes.
Defense is at the plea.
Yes, I had spoken to Rick about it with the no contact order. We were just gonna ask for a slight little change to it. Basically,
What I can tell you is the court is going to order no contact. So if that's something that is a deal breaker for you all, then that's a deal breaker for you. But I'm not going to remove the no contact order.
Hey, yes, ma'am.
Do you still wish to go forward with this plea? All right, state is at the plea.
it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel at the meeting, such motions.
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be 100 hours community service restitution, the BIPP, and TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, Your Honor, at this time, table offered evidence, it is Exhibit 1, all attachments.
I reviewed that with my client, Your Honor. We have no objections.
All right. Did you review the waiver? Oh, have you spoken to the complainant?
Yes, we have, Your Honor.
All right. Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right. So according to the police report, it says this was assault of a pregnant person. I'm assuming she was pregnant. Well, is she currently pregnant? Was she pregnant during this?
At the time, yes, ma'am.
All right. So are you in love with her?
We're supposed to be getting married.
Well, not on my watch. That marriage is off. You can't have any contact with her.
You tell me, ma'am.
I mean, I don't understand. If you love her, then why are you putting her hands on her in violence and at Kentucky Fried Chicken, no less?
When I understood it was dismissed, ma'am, that didn't happen.
Oh, well, let me just tell you what it says in the police report. The victim told dispatcher she was being assaulted by her boyfriend at the restaurant. I made contact with the victim while she was outside the vehicle. Victim stated suspect assaulted her before. Victim stated that there is a no contact order in place. While victim was in the drive-thru ordering food, victim stated suspect showed up to the incident location on foot. Victim stated suspect started arguing with her through her car window, telling her they need to get back together. Victim continued to argue with suspect. Then victim stated suspect punched her 3 times while he was standing outside of the vehicle. I could see redness on victim's cheek and dried blood on her lips. Victim stated that she would be willing to make a statement. I guess she's changed her mind or you've talked to her. And then it says suspect refused to tell me his birthday. He ended up getting your birthday from the victim. Shortly after, suspect stated he came to the location with victim. Suspect stated that he is aware there's a no contact order between him and the victim. So you're still violating protective orders. So what I'm telling you is for the 4 years that you're on deferred adjudication in this court, you're not getting married to her because you're not having contact. And I'm not going to allow you to get married to her by proxy. Maybe during these four years where she has no contact with you, she'll be able to reflect that she can do better. So it's 4 years deferred adjudication, a $1,500 fine probated, affirmative finding of family violence. There's to be no contact with the complainant. If the complainant comes to your house trying to get back together with you, you better call the police and say that you have a no contact order. If she calls you and says, let's get back together, don't go over to her house because I'm telling you can't have any contact with her. Do you understand?
Yes, ma'am.
Do you have any children with her other than maybe the one?
Yes, no, ma'am. Other than that.
Do you have any other children other than the one with her?
Yes, ma'am.
And how many other children do you have?
I got 7 altogether.
All right, and what are their ages?
I really don't got custody of them, so I don't really.
Well, what are their ages?
I'm not sure, ma'am. I don't got custody of them.
So you're just being fruitful and multiplying. Okay.
Young at the moment.
How old were you with your first child?
19, I believe.
All right, and how old are you now?
30.
And are you employed?
I was, but we came up here for vacation, so I'm not currently.
Doing what?
We was up here for New Year's.
You came up here for a few years for vacation?
New Year's.
New Year's, and never left.
So I got locked up.
All right, 4 years deferred adjudication, as I previously stated, $1,500 fine, probated, affirmative finding of family violence, no contact with the complainant, regular reporting by Zoom or in person, regular random UAs, BIP, TAP evaluation in custody, follow recommendations, proof of employment within 30 days of release, no employment as a home health care provider or with minors, no unsupervised contact with minors, 100 hours of community service restitution. The court is going to order parenting classes. Once that's completed, parenting classes will be, the community service hours will be deemed satisfied. GPS partial for employment until further notice. And field visits 1 time per month until further notice. Probation, is there anything else?
That GPS going through the jail judge?
Yes, waive fees and take in consideration 2025 PF 00972.
Excuse me.
Mhm.
On the GPS, I didn't know I was going on the GPS.
Oh, yeah, you're gonna be on GPS because I need to know where you are.
I don't got all.
He doesn't have an address.
Oh, they'll work with him on getting him an address.
I ain't got no choice but to say.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived, I'm sorry, I need that. And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am. But this is just for the bond, breaking bond.
No, this is for your being on probation. You're going to be on GPS in this court until further notice.
And
This is for Vasquez.
okay.
That's one of them.
All right, Noah Cock.
Oh, and we did this TIC the other case, right?
Yes.
Yes, sir.
That's an issue.
Well, and what happens if, I didn't even know about this violation, however, I had started a couple days earlier communicating with one of the assistant district attorney about this case, where I showed her videotapes, police reports of the complainant going over to my client's house. Even showed a video and a picture where.
But see, here's the, and I understand what you're saying, Mr. Cox, I understand, but here's the issue. The issue is this new case that's before me, the repeated violation of court order or bond condition. The issue is whether or not this occurred at his house. Now, that doesn't mean that that makes the case not one that the state can go forward on, but it will help me make a decision on whether or not he violated the conditions that I set. So what I want to know, and what parties need to let me know, is whether or not this offense date of August 29, 2022, was that when the complainant was at his home, or is it somewhere else? And I will tell people these violation reports, I know other courts don't do this, but I always set hearings on violation reports, but technically I don't have to set a hearing on a violation report. I can just make a decision on what's presented before me. So if you all want to sit back and confer a little bit to let me know whether or not this offense date of August 29, 2022, whether or not that occurred at his home, that'll be something that I would be interested to hear.
Hey, Judge, I can just go ahead and tell you it's not.
Well, no, I'll let you all sit back and confer.
But if what I was just about to say, Jay, if you have a photograph of the complainant breaking into his house, then how do you bring him forward? Well, when he can't keep her away, what can he do?
I understand, but
she breaks in. I got the photograph of her breaking into his house, halfway in, halfway out.
No. I understand if y'all want to present that, you can.
We're ready.
All right. Do y'all want to proceed now, or would you like to come back this afternoon so you can have everything you need?
Well, it's so many incidences, Judge. I may need a little bit more time. I mean, to give a court a good picture of it. But it just seemed like we had, when I was in law school, I don't know if they still do that. They had some called the clean hands. You know, you can't come before a court. We call the court of law, court of equity, with unclean hands. You know, so my position is that they're pushing something. And what about, I mean, I got 5 police reports.
All right.
So I would think, Judge,
So this is what I'll do. I'll let you all confer some more. And we will come back at 11:30. That gives everybody an hour to present whatever they want to present. Can I have parties announced for the record for the state? Defense?
Cornelius County.
And are you Mr. Salazar?
Yes, ma'am.
And probation, this is for regular probation?
Yes.
Did you understand you're charged with assault of a pregnant person? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court doesn't have to follow it. If for any reason the court does not follow it and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, on the no contact with the plaintiff, the Salazar would hope that the court would consider no harmful or injurious contact, and because they have children together, and the complainant actually in the case judge didn't want to actually pursue it, and we're just hoping that the court will consider the no harmful contact, that of no contact.
All right. State, have you had contact with the complainant?
We have.
And does she want a no harmful or injurious contact?
She has not clarified on that specifically, whether she wants the no harmful or just no contact, but based off of these pieces, I believe she would want a no contact order. I can't say that for sure. It's an interesting situation.
And Mr. Cox, I want you to know, I recognize you as an officer of the court, and I do know you as I know the state. So what you're telling me, I do take it as truth, but I always like to know whether or not the state has had contact with the complainant, and the complainant is aware of the plea and those type of things. So is she aware of this plea?
She's aware of the terms of the plea, the term being the 10 years probation. But again, specifically, I'm not sure if they've discussed the no harmful or injurious contact.
Okay. Is there anything you wish to say, Mrs. Salazar?
No, man, I was just we have kids together. And
All right. Kids are Billy goats, baby goats. Those
Yes,
were
ma'am.
kids.
Yes,
You have
ma'am.
children.
I'm just trying to finish my college. So
Here's my question. Are you employed?
yes, ma'am.
What do you do?
I'm working at mobile home installers right now, but I might go back to doing electrical work.
All right, I'm going to tell you, here's my issue with the no contact versus no harmful or injurious contact. What I have before me is, from reading everything, you assaulted her while she was pregnant. So for me, that should be no contact. Now, if maybe once you've completed or started the BIP course and I speak to her, then maybe I'll reconsider. But for now, the answer is no. And when I read the police report, there appears to be some altercation, and then you went off with the child and then came back with the child. And that's a lot of confusion, chaos, and violence to be happening in front of young children. And how old was this child?
She was about 6 months.
So the oldest child was 6 months. So the child who was around when this happened was 6 months old. Is that what you're telling me?
Oh no, she said she was pregnant, but she had already had her.
No. So she's saying she was pregnant. You're charged with assault on a pregnant person. You're saying that there are 2 children or
No,
just
no,
one?
no.
Just only one? All right.
I mean,
Yes.
I actually have an affidavit. Prosecution. I know that's not.
Yeah.
Seeing them, but it just.
Any objections to the
for
court reviewing that?
To know that And if the court would, I don't know if the court remembers, one time we had a hearing on this case, and this was a case where, the picture of somebody, a young lady trying to get into the window.
Yes.
That's,
Oh, no, I remember this case.
And Judge, just so you are aware, one of the cases being taken into consideration is about 2 weeks old and it's another detail.
Yes. Well, here's the thing. We're going to start out with the no contact. You know, when people come before me and they want to have contact because they have children, it's like the time of to think about that is before we get to this point. So show me something. Take some anger management classes, get your life in order, get your household in order. Then the court would consider, you being allowed to contact. Do you have family support?
Yes, ma'am.
Who do you have in your life supporting you?
My grandma, grandpa, my dad.
All right. And does she have family supporting her?
She all she had was me.
Well, no, I mean, people have more than just you. Does she have a mom, a dad, an aunt, a brother, a cousin, a sister?
No, her father committed suicide in front of her. So.
All right. So then this is what's going to end up happening. If there's, for you to see the child or something like that, you all have to make arrangements through a third party. You can't contact her.
so even if, if the victim communicated to the state that she wanted to have contact, would the court consider that? No, not at this point.
Not at this
We
point.
need a little time.
Yes.
Water to blow under that.
Under the bridge.
Under the bridge.
Yes. All right. I appreciate that, Mr. Cox. Yeah, because I want to make sure that the issues and the confusion that brought us here
Yes, ma'am.
don't occur again.
Yes, ma'am.
And what I can tell you is when people say they love each other, problems are not solved with violence. When it gets to the point where people want to be violent with each other, maybe it's a relationship that people should walk away from. And if there's children involved, then you walk away and you say, you know what? I will always love you. We will always be friends because you're the mother of my child or you're the father of my child. But you and me, as far as a intimate or romantic relationship, not going to happen. And sometimes that's where we're at. I really wish there was a way that I could give people couples counseling, give people self-esteem counseling, give people financial counseling so they won't be dependent on somebody. It's best to go into a relationship having independent means and being able to support yourself without that other person, because then you can walk away. And I can only deal with you specifically
Yes, ma'am.
because I don't have more information about her or about your relationship or what goes on in your household. But what I'm telling you is you cannot have contact with her. If I find out you have contact with her, you're going to be looking at 10 years in the prison. You understand? If she comes over to your house, and as Mr. Cox showed the court before of her climbing through your window, you had better call the police and say, hey, I'm on probation. I'm under a no contact order. And this complainant is coming through my house through the window.
Yes, ma'am.
And don't even do that thing where, oh, we're getting along fine. I'm going to let her come over because guess what? It's the holidays. Tempers run high. And then the police get called. And what's going to end up happening? Your attorney's going to want to come in and say, oh, she's climbing through a window. And I'm going to ask you, did you call the police? So don't do it. You understand?
Yes, ma'am. I have called the police on several occasions, though. I made several police reports that I do have.
All right. So, I mean, if she comes over, that's what you're going to have to do. So the court is going to, as previously stated, find you guilty, sentence you to 10 years in prison, suspended and probated for 10 years. There's a $1,500 fine that'll be probated. Take in consideration county court cause numbers 698-065, 670-474, grand jury number 782-139, 2022 CR 6538, the BIP course, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with booster. Court is not requiring it, but if you do, then 40 of those hours will be waived. I'm going to ask for parenting classes with Triple T. If you,
I think it's completed.
all right, well, we'll see.
I just recently completed it now.
So he
From
showed
who?
proof?
Shows, when did you complete
Got a
this?
certificate, like,
When?
maybe a month and a half ago while I was doing my college, I did it for CPS.
All right, so Child Protective Services is involved in this as well. Okay. Is Child Protective Services still involved?
We had court the other day. I think that's to be the end of it.
All right, CPS compliance, if applicable, just provide the parenting classes certificate to probation. So probation, if he has parenting classes certificate where he successfully completed it from CPS, then the court will accept that. We're going to do CPS compliance if applicable. There's to be no contact with Amanda Bondoc until further notice. The BIPP course, and Mr. Cox, you can check and see if they did the BIPP course as a part of CPS. I'm not sure. There's to be regular reporting by Zoom or in person. I'm going to want random field visits 2 times per month. You can do those for 6 months to see how they are. And then if they're fine, you can slowly start tapering downward with the field visits. And the field visits, if you want to, can count as his appointment. Is there anything else that you need from me in order to be successful?
Not at the moment, ma'am.
All right, I'm going to show you what's entitled trial court certification. Before I close the record or go to the trial court certification, I want to explain to you what an affirmative finding of family violence designation means. And then if you decide that you no longer want to do the plea based upon that, let me know and I'll allow you to withdraw your plea. So with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Oh, yes, ma'am.
And with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Do you understand? You want to talk to your attorney about that? Or do you understand?
Oh, that's fine.
All right, so knowing those things, do you still wish to go forward with this plea?
Yes, ma'am.
All right, so there's an affirmative finding of family violence. Is there anything else with regards to sentencing? All right, and probation, the minimum advisory fees for Mr. Salazar, please. All right, we can go off the record. So what are these names on your tattoos about?
My son, Matthew II, my daughter, Annabelle, well, my wife, which is, Amanda. And then I just have blessed right here. I just have my kids' names, and then I have my other daughter's name right here, Zoe.
So how many children do you have?
Oh, I have 4.
What are their ages?
Well, I got a 14-year-old, which I haven't seen in a while, and then I got a 10-year-old and an 8-year-old, and then I got a 2-year-old.
What are their dates of birth?
My oldest, hers, is February 24th, February 24th, 2014.
Okay.
And then it's 1/16/12, 5/12/14, and then 10/29/2000.
All right, so here's the thing. You have a felony conviction. It's not the end of the world because one, you're not going to prison, right?
Yes, ma'am.
You're going to have to start making better choices or you may end up in prison.
Yes, ma'am.
Hopefully you want to be the type of father that your children look up to you.
Yes, I want to be there for my kids. Like I don't want them to grow up the way I did without a father.
That means you're going to have to change your ways. You understand?
Yes, ma'am.
All right, I'm giving you a chance on probation. The key to being successful in probation in this court is being open, honest, and communicating.
Yes,
You
ma'am.
understand?
Yes, ma'am.
All right, good luck to you.
Thank you very much, ma'am. I appreciate it.
All right, you're welcome. Mr. Salazar,
Yes, ma'am.
showing you what's entitled motion to revoke community supervision and First Amendment motion to revoke community supervision. Did you review that with your attorneys? With your attorney, did you understand it?
Yes, ma'am.
Are you the same Matthew Salazar who was placed on community supervision in 2022, CR 3264, for the offense of assault of a pregnant person on December 8, 2022 for a term of 10 years? Is that you? You need to speak up.
Yes, ma'am.
All right, state.
Yes, Your Honor, we're proceeding on the first violation under violation number 2.
We're waiving and abandoning all others.
All right, so which violation?
The first paragraph.
If y'all want to read that into the record. And I need a stamp, please, for a motion to revoke.
Violated condition number 2, on or about 13th day of February 2023 in Bear County, Texas. the defendant-
Everyone, you all need to whisper, we're on the record.
The defendant, Matthew Salazar, did then and there illegally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that, true or not true?
True, man.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 10 years in prison and up to $10,000, and up to a $1,500 fine.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
And what are you all requesting?
And we're requesting that that he have to participate in a TAP evaluation. It's my understanding one hasn't been done up to this point. That he be referred for intensive outpatient treatment. That he have to call into the UA hotline, and then that a felony drug court referral be issued. And then we're hoping, obviously, it's been a little bit since this previous violation. We're hoping if he's given an opportunity out in the community, that if he can make these appointments and show that he's willing to participate forward, move forward in his probation and actually start taking accountability, that'll get him on the right track. We'd also ask that if any of these appointments moving forward don't happen, that indicates that he's not moving forward with his probation, that we'd issue an ATR at a later date.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Matthew Salazar.
All right, so what's going on in your life? Why have you been using?
Well, to be honest, at that point, back then, I just depressed. I lost everything. I lost my family.
Okay, you're gonna have to,
I lost everything. I was just depressed. You know what I mean? Somehow, somewhere along the line, I messed up, and I know consequences for my actions. And right now, I'm at a better point in my life. I have some kind of structure behind me. I have something to look. I have.
open your mouth.
Oh, I have a better point in my life right now, and I have some sort of structure behind me now to help me out, and it's something to look forward to. And
What's your structure that you have behind you now?
well, now I have my dad. He's back from. He was overseas. He's back now, and
Okay, so here's the thing. I know maybe you're nervous, but you're gonna have to open your mouth
Yes,
to
ma'am.
speak and stop mumbling,
Yes,
because
ma'am.
when you do that, guess what? I can't hear, court reporter
Yes,
can't
ma'am.
hear.
Oh no, my dad came back from overseas, so now he's here to help me out. Get me on the right track. And I've been doing good. I got a job. I'm working.
What do you do?
I'm an electrician, and I work at a corner store at night.
All right, so when's the last time you used?
Not.
I mean, here's the thing.
Oh no.
You started your sentence with, to be honest,
Yeah. No.
and your
I was gonna
attorney
say-
will tell you, usually when people say, well, to be honest, what's about to
I was-
follow is not honesty.
I was gonna say, Matt. I probably used it that 1 or 2 times, but I came out dirty. But I was smoked weed like before I got arrested.
Okay,
And I'm beating.
all right. And probation?
Yes, Judge, I didn't hear his last answer.
Oh, he said he smoked weed.
Okay. Judge, in addition to everything that the state has mentioned, I would add sober support meetings.
Okay. All right, any questions from either counsel?
Nothing to finish.
All right, this is what the court is gonna order. The court is gonna order a TAP evaluation that can be done out of custody. If you miss that TAP evaluation appointment, and there's not a good reason for it, by good reason, I mean, hey, I'm in the hospital, a warrant's gonna be issued for your arrest. You understand? You're gonna call into the UA hotline. here's the thing about the UA hotline. When you call it, they may say, hey, you need to come in and do a test, right? And maybe you're at a job site and the job won't let you leave. So you're like, I'm just not gonna go do the UA hotline. Nope, what you need to do is you need to pick up the phone, call your probation officer and say, I'm at a job. This is when my lunch break will be today. Can I come in over my lunch break? You understand? There is going to be referral to felony drug court. And there's going to be 90 sober meetings in 90 days. And follow all TAP recommendations. Unless they're asking for inpatient treatment. We'll start with outpatient treatment if they're asking for inpatient treatment. With the referral to felony drug court, do not miss that appointment.
Yes, ma'am.
If he's accepted into felony drug court, then of course we won't need to follow the TAP recs. Is there anything else, probation?
Judge, there have been times where under the court's direction, if he can't drop what he's doing at the job site, you allow 24 hours for that submission of the UA. Is that a case? Is that?
Yes, but the first thing he needs to do is call probation and make sure that you can't squeeze it in over your lunch break.
Yes, ma'am.
But under no circumstances is that UA to be performed after 24-hour time period. You understand?
Yes, ma'am.
All right, anything else, probation?
No, Judge.
Is there anything else you need from the court in order to be successful?
No, ma'am, I think I really need just help and support so I can get back on track.
All right, we can go off the record. Here's the thing. Everything that you do, you know, you're looking at 10 years in prison potentially. So you're being given the tools, so perhaps you won't use. Everyone, when we're on the record, don't approach. People don't read that sign. All right, so you've been given the tools. If there's an issue and you see that you're going to use in this court, you know what you should do? Pick up the phone and call probation. Pick up the phone, call your sponsor. You should get a sponsor. You understand?
Yes, ma'am.
All right. And if you feel like probation is not addressing your issue, you can always come back to the court. You understand?
Yes, ma'am.
But above all things, don't just throw up your hands and say, whenever they pick me up, they pick me up, because then things start piling up. You understand?
Yes, ma'am.
All right. Good luck to you. And do I need to recall the warrant again? All right. And recall the warrant on this case, please. Yes. But you can put, no, don't reinstate the bond. Just recall the warrant. His case is over. So he shouldn't have a need to make a bond.
Oh,
Yes. All right, we're here for a motion to set bond. State, have you reviewed the motion?
I have, Your Honor.
All right. Do you all have a proposed agreement?
I do believe, I'm not sure if we're in agreement, but the state does have a proposal.
All right. So state, what are you requesting?
The state would be requesting a $30,000 bond, no contact with the complainant, and I guess any other conditions that were ordered.
All right. In defense, what are you requesting?
Judge, we're requesting the original bond of 15,000. There's no complaint on, as far as I know, as far as the motion to revoke is concerned, but that's not an issue. And that was part of his probation anyway, so he's.
Okay.
Right, no contact with the complainant in the probation case.
All right. So am I correct in assuming that the reason why he doesn't have a bond is because of the motion to revoke, that a motion to revoke was filed?
I'm assuming that, Judge, because you're the one that remanded him without bond based on the motion.
All right, let me see if that's the reason, because sometimes the bondsman is on the bond.
No, from what I
They remove
understand,
themselves.
from what I understand, when I was looking at Odyssey, and the court may read it different than I did.
Mhm.
When the court filed or signed the MTR, you remanded without bond.
Okay,
To my knowledge, that's the case as well.
okay. My Odyssey is moving very slow today.
I'm not surprised.
Well, the good thing about Odyssey moving slow is you can always blame stuff on Odyssey.
Right?
But once Odyssey, if Odyssey,
Well, honestly, just so the court, Mr. Salazar knows, honestly, I represented Mr. Salazar a few years back. The MTR was filed. Odyssey kept me on as an attorney, but I was never notified that I was appointed again for this MTR. So after his family called me up a couple of times, I spoke with Norma. She got me on and we got this file.
all right, what I can tell you all, what I'm reading in the Odyssey, at least the court record, I ruled on a first violation report. And let me see,
That was in March. 24.
it was, just one second.
I
Oh,
did see like
sorry,
7,500.
7,500.
Okay.
But no, let me just tell you the way Odyssey has it written. Odyssey has it written as, we can go off the record. Odyssey has it written as 7500. There's a decimal point, then 00, and then 8 zeros after that. So, all right, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. The questions I'm going to ask you is related to your bond. They're not related to your case. Do you understand?
Yes, ma'am.
Yes.
All right, so have you ever been diagnosed with any type of mental health issues?
Yes, ma'am. I'm getting treated downtown for PTSD and severe depression disorder.
All right, and have you ever in the past used any type of illegal substances?
No, ma'am. I'm currently not doing anything. I don't even drink. I just cigarettes. That's it.
All right, and if you were released, do you have someone that you're staying with?
Yes, ma'am. I do. I have my own house, and then I could go stay with my father. He's a retired Air Force.
All right, and are there any minors that will be staying in the house with you?
No, ma'am. Neither at my house or at my father's house.
All right, thank you. Any objections to the court?
Yes, ma'am.
Sorry, any objections, defense, to the court reviewing the motion to revoke?
Noted.
All right, and just so you're aware, Mr. Salazar, I'm just reviewing the motion to revoke. I'm not taking it as true, but I'm just trying to make sure that there's nothing else that's in here that I should be aware about as far as it relates to the complainant. Do you understand?
Yes, ma'am.
State, will you make the complainant aware of the fact that a bond is being set for Mr. Salazar? All right, so the state is asking for 30, defense, you're asking for 15.
Yes, sir.
The court will note that the previous bond was $7,500. And part of the motion to revoke in the allegations is that your client has been missing.
There he is, Jim.
We found him. All right, so counsel, I can set the bond at $30,000. And I think that will be enough to ensure his appearance. Or either I'll set the bond at $20,000 with GPS.
$30,000, Judge.
Okay. So the bond will be set at $30,000. And Ms. Ferguson, I need this set for a contestant.
Exactly, is that on March the 6th, Judge?
All right.
Already was previously, did you want me to move it or?
No, you can keep it for March 6th. So we'll come back on March 6th.
They did not grant him a PR bond, mostly because he's on deferred out of the 232nd District Court for assault on a pregnant person. That's a different complainant. The complainant there was his sister. So.
Hold on, you want me to bring him out?
Sure.
Stephen, do you mind bringing someone out, please? Yes, sir.
I was just giving you a little preliminary before you brought him out.
I want him to hear it.
I understand. But he went to probable cause court. They denied a PR bond. He does have family here and he is employed. And we're asking the court either for a bond reduction or for a PR bond. He's been on deferred since January of last year.
Correct. Manuel?
Yes, sir. No, sir.
Yes, sir.
The East,
Yes, sir.
how's jail?
To be honest with you, it's not nice.
Great.
It's not nice at all. And It
That makes
if
me very, very happy because I hope it's one of the most miserable, rotten experiences that you ever had.
it is, sir, and I wish to never see it again.
The problem is you keep doing things to land you in there.
Yes, sir, and I will try my best to do more to not end up back in here, sir. I promise.
The road to hell is paved with good intentions, Mr. East.
I know, sir.
You're on a very serious probation for assault of a pregnant person. And now picked up terroristic threat. You're now facing another year in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, sir.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes,
I don't
sir.
even know what happened to your case. All I know is that you're on a serious probation,
Yes, sir.
and now you've picked up another case. So let's see what happens
Yes, sir.
and whether you deserve to be let out.
Yes, sir.
Please.
On April 29, 2024, in Harris County, Texas, the defendant threatened to kill the complainant and the child that they shared together. Complainant felt in fear and pepper sprayed the defendant while on the phone with the 911. Defendant admitted to the threat, stating it was out of anger.
What do you think? What other prior, does he have any other prior criminal history from anywhere else, juvenile?
So Judge, his priors are all in county. He has assault of a pregnant person that he's on probation for against his sister and an AFM, which was, it looks like it was.
So he has another assault.
He has an AFM from
22.
I think it was the same.
It was refiled. So it was an AFM that was refiled to assault a pregnant person.
That was his sister. The complaint was his sister.
Correct.
Not
The
the same
complainant on that
complainant.
case was his sister, and the complainant in this case is the child of, or the mother of
His child. He's not compensating baby mama.
Yeah, try not to. Did you make the
Mr. East, what do you do with your life now?
Right now, I'm working at a thrift store. I'm not getting paid that much, but I'm getting paid just enough to take care of the child. And right now,
How are you going to take care of a child? You can't even take care of yourself, Mr. East.
I'm still learning. This is my first child, Your Honor. This is my first child, Your Honor, and
You know, the problem is that with all the anger that you have, if a child sees it, what are they going to do?
they're gonna feed off that same energy, sir.
Right.
And
They're going to be just like you.
man,
If they see you beat mama, threaten to kill mom, what are they going to do?
same thing, but I would never touch my mother, my child's mother. I would never. I would never.
Patient for the very same thing, Mr. East.
I understand, sir.
I don't know, Carl. I don't know. You know, I'm not.
He's a lifelong resident of Harris County, Your Honor. He's not a flight risk.
I'm not. My concern is the public.
I understand. And the conditions are right now, he does have a place to stay. He lives on Tidwell. The mother of his child lives at a different location. And he orders are here for him to not have any contact with either with her, the complaining witness.
What was the tipping point here? Why did he get so angry?
4 o'clock in the morning,
4 o'clock in the morning.
I got a phone call from a girlfriend of mine because she was having some problems of her own, but I was sleeping and I didn't hear her phone call or her texts. So while I was holding the baby, I asked her.
4 in the morning.
4 in the morning,
Yes, sir.
I believe he responded to some text from another female judge, and that's what caused the altercation between him and his mother of his child, which is understandable. We've talked about this. But he did not assault her, and as a matter of fact, he was pepper sprayed himself during the course of the altercation, after he made the threat. He admitted to the officers that he made the threat out of anger. He had no intention of following through on it. He is gainfully employed. He just started his job last week. Hopefully he still has it. He hasn't been bond forfeiture before. He's not failed to appear in court. He's not a flight risk.
I will make you a deal, Mr. East.
Yes, sir.
The only way, because I think that everybody should be given a chance.
Yes, sir.
You weren't given a chance here. You're on probation, which is a serious.
Charge.
What I want to see though, is you proactively addressing your anger.
Yes, sir.
The only way I will let you out is if you take it upon yourself 3 times a week
Yes,
to
sir.
do anger management classes somehow, some way.
Yes,
And
sir.
I want proof on a written piece of paper that you're actually doing some kind of anger management
Yes, sir.
3 times a week.
Can we make it 4 times a week? I'm sorry to interrupt you, Judge.
3 is sufficient.
You need to do something that's realistic.
Yes, sir.
Don't overkill because you're setting yourself up to fail.
Yes, sir.
All I want is you to address it. And the way that I can do that is by dangling a jailhouse key in front of you. So you hold the keys to the jail. I want you to do 3 anger management classes a week.
Yes, sir.
And I want you to bring a proof to me every Monday that you've done 3 classes a week.
Yes, sir.
And the first time you falter, I will yank the bond and I'm going to put you in jail. You now know that you have no one to bond you out. So if you go to jail, you will be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir. I understand.
Give you this one and only chance.
Yes, sir.
Make me proud. Don't fail me.
Yes, sir.
So we need to find some kind of anger management class. I'm sure that there are free ones. It is up to you to find it. It's not up to Carl. It's not up to your girlfriend, not up to
Yes, sir.
you.
Yes, sir.
And I want you here every Monday with proof in hand that you've done the anger management classes.
Yes, sir.
3 week. No dope, no alcohol. Carl, I'd like to know who the extramarital person is, and we need to cut that off so that there are no reasons for her to get upset or you.
Yes,
You
sir.
focus on one and you focus on that child.
Yes, sir.
Understand?
Yes, sir.
This is the only chance you're going to get from me. You will not get another one. If you don't believe me, look around.
I believe you on. I believe you on.
Jeez, make me proud.
Yes, sir.
Judge, do you want him to have no contact with the complaining witness, or do you
I would
want him to
say
have no
until
contact
things are better, yeah, no contact and no weapon.
at the present time?
Yeah. With this one and the other probation case as well. Yeah.
I understand, but
Yeah.
the other probation case, the complainant there was his sister. You want no contact with her also?
Yeah.
Okay, fine. Just want to make sure he,
It's probably already a condition of the felony probation.
well, I understand. I just want to make sure that he understands while he's here.
It's already stated that I shouldn't have contact with Malaysia triplet or have any.
Stop. You know what's expected of you.
Yes, sir.
That's the only thing that matters.
Yes, sir. Thank you, Your
Thank you,
Honor.
Your Honor.
Thanks, Carl.
On the bond, is it a PR or a reinstatement or?
No, it's a PR because he never got a bond
That's why I
whatsoever.
wanted to make sure.
Yeah.
Come on.
Thank you, Judge.
Carl, thanks.
Last name already died.
Where have you been? Do I know you?
I mean, I hang out here and there, Judge. Yeah, for now.